Good evening, everybody. My name is Judge Janet Baer, and I'm a judge in the Northern District of Illinois in Chicago. Welcome to the IWIRC program on Demystifying the Bench. With me tonight, I have some wonderful judge colleagues in Judge Leisha Beckerman, Judge Mary Jo Heston, and Judge Kim Tyson. Before we get into our program, however, I have some administrative matters I need to tell you about. First of all, there is a chat function, which is on the right side of your screen. Please have it open during the session to view the CLE CPE pop-up code that will be posted about halfway through the session. Please make sure you write down the code that pops up or otherwise put it somewhere safe because you will need it at the end of the conference to get your credit. CLE CPA credit information will be sent to all attendees at the last session on May 27th for all sessions. So please retain all the pop-up codes for all of your sessions so you can get your credits. If you have questions tonight for the panelists, please type them in the chat section. We are happy to take questions as the program proceeds. We want to be responsive to what you're all thinking about and what you are most interested in hearing about. Finally, we want to be sure to thank our IWIRC sponsors today. Thanks to the support of its valuable sponsors, IWIRC has been able to expand its membership benefits, increase its educational programs and networking events, as well as grow the number of local networks worldwide. IWIRC sponsors receive a valuable range of benefits, including consistent exposure of their brands to over 1,700 members from all facets of the restructuring and insolvency industry. Today, we're highlighting our platinum sponsors, BMC Group, CR3 Partners, FTI Consulting, Getzler Heinrich, Lowenstein Sandler LLP, PwC Canada, SCNH Capital, and Secor Law. You can see these and all of the amazing IWIRC sponsors by clicking the sponsor tab on your screen. And with that, let's begin. I'm going to ask each of my judicial colleagues here to introduce themselves and tell you a little bit about where they sit, the year that they came onto the bench, and describe a little bit about their career path prior to their appointment. And we'll start tonight with Mary Jo, who in order of seniority has been on the bench the longest except for me. I'm the old lady here, having been on since 2012. So Mary Jo, why don't you tell us a little bit about yourself, where you came from, how you got here?
Sure, thanks, Jan. So I'm really happy to be here tonight because I think this is a really important topic. And so my meander into bankruptcy was not a direct path, as I think is true of many of the panelists. My undergraduate degree was actually in occupational therapy. So I was an occupational therapist for a couple of years. But once I got into bankruptcy, I'd done an externship for a bankruptcy judge in my third year of law school. And that got me very interested in bankruptcy. Then I clerked for a district judge for a U.S. district judge for a year, and then came back to the judge I'd externed for, who's still alive, by the way, is 99 years old. I worked for him for a very short period of time, and then the court system created what they called the Estate Administrator Program, which was the predecessor program to the United States Trustee Program. So I worked in that for about 5 years. And then when the U.S. trustee system came in, I was appointed as the very first U.S. trustee in the Pacific Northwest, covering Washington, Oregon, Idaho, Alaska, and Montana, 978,000 square miles. And so after that, I then went into private practice. I served a single 5-year term, and I worked for a regional Pacific Northwest firm in Seattle and Portland for 25 years doing commercial bankruptcy, commercial litigation, and the like. And I was appointed as judge in February of 2017. So I've been there about 4.5 years is all. It's the best job I've ever had.
Thanks a lot, Mary Jo. Kim, I know you were also appointed in 2017. Why don't you tell everybody a little bit more about yourself?
Thank you, Jan, and good evening to you all. I'm thrilled that you all are attending this program because I agree with Mary Jo, it's an important one. I sit in Colorado and took the oath in May of 2017. So I've just gotten to my 4th anniversary on the bench. I, like Mary Jo, also meandered into the law and into bankruptcy. My undergraduate degree was in biology. And after working 3 years, I decided to go back to law school because I thought it would open more doors than it closed. After graduating from law school, I clerked for a judge on the Kansas Court of Appeals. And then his good friend, one of his good friends was a bankruptcy judge in Kansas, and I got recruited to work for him. I had to admit, I barely knew how to spell the word bankruptcy. And so I was able to audit a class with one of my law school professors while working for the Court of Appeals. After my 2 clerkships, I moved back to Colorado, which has been home since I was 5. And I worked for a solo practitioner before she went on the bench, and then a 4-person bankruptcy boutique firm, then a large multi-state firm, and finally a medium-sized regional firm where I began its bankruptcy practice. Over the years, I represented most of the constituencies in both business and consumer bankruptcy cases. And then in addition to my law practice, during the last 6 years I was in practice, and prior to my appointment, I served as a Chapter 7 trustee.
Great, thank you, Kim. And now we'll turn to Lisa, the youngest judge on the bench in terms of seniority. Been on the bench, what, a whole 3 months as of today, I think?
Yep, 3 months. It's my 3-month anniversary, Jan.
Congratulations, we're so happy to have you.
So my background, I think, is certainly less diverse than everybody else's. I was one of those people that got out of law school. Before I was a lawyer, I have an MBA in finance, and I had worked in the area of equity research. And then I ended up, after I got my MBA, going to law school. And when I got out of law school, I went to work for a large firm, Strickland Levan, and the bankruptcy group. I was trying to find something to fit my legal background and my business background together. And that's what I thought, the bankruptcy process was great for me. Also, I'm one of those people that gets bored really easily. And one of the good things about bankruptcy is you're never bored. So it was a good field for me. So I was there at Strickland Levan for 10 years. I made partner. And then literally the day I made partner, 2 of my other partners at Strickland Levan took me out for coffee, like probably I'd been a partner an hour, and asked me if I wanted to move with them. So I did eventually move, like 5 months into my being a partner at Strick, to Aiken Gump, where I was for 21 years. And my type of practice was obviously very large cases all over the country, really what people mostly call mega cases. And it's a lot of Chapter 15s as well. And that's what I did. So so that's sort of how I ended up what I did before I went on the bench.
Thanks, Lisa. And just in terms of my background, talk about diversity. And when you're thinking about what do you want to do you want to be a bankruptcy judge? I think when you hear the backgrounds of all of the folks here, you understand how diverse we are. I was a radio, TV, and film major in college. I wanted to be the next Lester Holt. That was really kind of where I was going. Or a sports broadcaster. I have 4 older brothers, and as you can imagine, there was a lot of sports in my home. So that was another possibility for me. On the other hand, somewhere along the way in college, I decided that I was a DJ, but that was not a career. And I decided I wanted something more substantive. And I had a wonderful professor in my undergrad class, Law of Mass Communication. And he was a lawyer, probably the first lawyer I ever met. And I somehow decided that law school might be something for me. My career path in terms of after law school is somewhat similar to Lisa's, in that I worked in big law firms. But before that, when I came right out of law school, I clerked for a bankruptcy judge, which Kim, I think, also did, and Mary Jo external, which was really kind of the motivating factor for me wanting to pursue bankruptcy and ultimately become a bankruptcy judge. But I did work at Winston & Strawn and Kirkland & Ellis for the great majority of my life, big law, mega cases, just like Lisa's, although I was generally on the debtor side, and had a great time in those cases. So with that, I'd like to now move on to our next topic, which is the selection process. How do you become a bankruptcy judge? And first of all, I want to point out to everybody, which you're probably aware, it's a merit selection process. We are not elected. We don't campaign. It's not a matter of who you know or what political party you're affiliated with. It's really based on who you are, what you've accomplished, what you can bring to the bench, and how you can help folks with access to justice. And with that, we actually have quite a mix here. We have 4 different circuits representing all 4 time zones in the United States here. We've got the 2nd Circuit, the 7th Circuit, the 9th Circuit, and the 10th Circuit represented. Now, the process for selection of judges varies from circuit to circuit, although they all use substantially the same written application. The materials that we've given you actually include the application from the 11th Circuit. I'd like to take a couple of minutes now to talk to each of our panelists about their circuit and the selection process there. And Lisa, since you're the newest judge, you probably actually remember this better than everybody else. So I'm going to start with you and ask if you can kind of describe the process in the 7th Circuit, which I understand in your case took a very, very long time.
Yeah, the 2nd Circuit, yes. So I think I failed to note I was a bankruptcy judge in the Southern District of New York. So yeah, our process is different than some other places. We actually have, you apply, you fill that very long and daunting application out. And then when you submit it, we have a merit selection panel that's made up of district court judges and circuit court judges. So 3 circuit court judges from the 2nd Circuit and 2 district court judges, generally from your district. Although this time, the second time I went through this, which I'll explain in a sec, it was 1 district court judge from the Eastern District and 1 from the Southern District. So because they were trying to fill out seats in both. There are no bankruptcy lawyers or bankruptcy judges involved in our process. That makes it very daunting, to be honest, coming from the bankruptcy world, because in the Southern District of New York, we have 40 district court judges. So the odds of my knowing whoever was going to be on my panel is pretty small. And then also the circuit court judges that I don't see very much. And then you're selected, they generally interview about 5 to 8 people. We have 1 interview and you're either selected or you're not. And I had applied back in 2015 when Judge Gerber left the bench, and I wasn't selected. In my district, most people are not selected the first time. It's almost like they require it. So but I was told to reapply, and obviously I was interviewed and I was seriously considered, but I didn't get the job, and so they had suggested the next time to apply. And so when I did, it was 5 years later, and we just about started COVID. My application went in days before the shutdown. So my interview for this job was on Zoom. I started as a judge on Zoom, and for virtual hearings telephonically. I had baby judge school on Zoom, or equivalent platform. So it was quite different, I think, than other people. And what Judge Baer was referring to, Jan was referring to about my selection process is, I applied in May. I applied in March, I was interviewed in May, and I was selected by the middle of June. But in our circuit, it's very secret. So then it's not told, it's not public, and then you go through your FBI check. My FBI check, all my forms were in by the end of June, and I didn't get my FBI check finished until my report was actually issued by the administrative office of the courts for 7 months, which is a really long time. It's supposed to take at most 4 months, 7 months. And it wasn't just me, my other colleague, Judge Jones, who was appointed to the bench 1 week before me. I mean, was sworn in the bench 1 week before, and we were both appointed actually the same day. But it was, hard to explain other than COVID, because of course, Judge Jones is a extremely reputable person. He was the 3rd ranking person in our U.S. Attorney's Office and had a high ranking security clearance. So it really made no sense. But the fact that he was going through the same awful 7-month wait probably kept me sane, because I probably would have gone insane thinking it was something I did. It's a very, kind of quiet process. After they interview you, wait. But finally it happened. I finally got my appointment. I finally got sworn in, and here I am.
That's an incredible story of how long the FBI check took. And by the way, I talked to Judge Gerber the other day, and he's very proud of you and takes a lot of credit for you being there.
He should. He was one of my references. He was so mad I wasn't picked the first time. He told me he would be my reference the next time. So
well, we're glad it worked out. Kim, let's turn to you. Lisa kind of explained the process in her circuit. How is it different in your circuit?
It's actually fairly similar. Colorado had 3 openings in a 2-year time period, and I ended up applying all 3 times. Obviously, the third time stuck. So like Lisa, and we'll talk probably a little later, the importance of just keep trying. In the 10th Circuit, the circuit appoints a merit selection panel, but it is comprised of 1 circuit judge, 1 district court judge. Both of them are typically from the district that you're in. And then 4 practitioners, 2 business practitioners and 2 consumer practitioners. And then in the interview, and that's all very secret, so you never know who you're going to see when you go into the interview. But you also have the circuit executive and the deputy executive there in the interview process. The interview lasted, after you fill out that long application, the interview lasted about 45 minutes. I'm not sure I know exactly how many people they interviewed. I know that they had basically 2 days of interviews, so I'm assuming it was probably about a dozen people. And then shortly after that, I found out I was one of the 3 finalists. Unlike Lisa, who found out fairly quickly that she got the nod, when I was told I was a finalist, it was mid-October in an election year, and the election occurred, and then 2 of the circuit judges were on the long short list for the Supreme Court, and for some reason, appointing the bankruptcy judge seemed to become a low priority. So we had been told we would hear by this Thanksgiving, then it was maybe Christmas, then in early January, they called, and the circuit executive called and said, we want to do another interview, which typically they didn't do, and that was a little surprising. So we had a second round of interviews for the 3 finalists with 3 circuit judges. And then like Lisa, well, like everyone, once you get the nod, then you go through the FBI background check. But I think the point there is that you may have a procedure, but it can morph not only morph between appointments, but it can morph during the appointment.
Interesting. You're the first person I've talked to who's talked about having more than 1 round of interviews. My process was quite similar to Lisa's in that respect. Mary Jo, what about in the 9th Circuit? You're on mute, Mary Jo.
We actually have 2 rounds of interviews. We have a local merit screening committee that includes practitioners and usually a local law school representative, a circuit court judge, a district judge, and a bankruptcy judge. And typically they narrow it down to 3, although in my year they narrowed it down to 2, which made keeping it a secret when I got it very difficult, because as soon as the other fellow found out he didn't get it, he was telling everybody and everybody knew I had it. But then the 9th Circuit has a standing committee that's made up of the chief of the bankruptcy judges in the 9th Circuit and the 3 circuit judges. And those people remain on that committee for a long time, so at least you know who you're going to be talking to at the second round of interviews. As far as the FBI check, I learned that I had gotten a job, I think in November. They started the FBI check. I was at the ABI Midwinter Conference in early December. They started it then, and by the end of December, my now colleague Brian Lynch was calling me and saying, can you start on the 10th? Well, I was living in Portland at the time and had to move to Tacoma. I said, of what month? He said, of January. So I don't know if that's representative of the very boring life that I've lived or, some other grand plan, but it went through very quickly.
Yeah, I think maybe the FBI check and how long it takes depends on what other priorities they have, because unfortunately, I think, as Kim said, we're not exactly a top priority, especially when they're looking at Supreme Court justices, COVID shutting down half the world, and you name it. But I think all of the appointments that have been made at the presidential level for district court and circuit court judges over the last number of years has really slowed down the FBI check for bankruptcy judges, from what I can tell. But it is a fun process. I will say, in terms of my own process, the merit, it's very similar to the New York process. And just like you've heard, it's very secretive. Until the FBI check is completed, it's not supposed to be said who got the Chicago position. And that was, generally speaking, the case. That is not the way it is in all circuits. And there's a story, I don't think it's an urban legend. There's a story that in one of the circuits not represented here, they announced right away before the FBI check, and there was a potential judge who did not pass the FBI check. There was something in that judge's background that created an issue, but that is not typical. I will say that on my merit, Mary Jo?
No, go ahead.
Yeah.
When you're done, I just had something that I thought about that.
I was just going to say, on my merit selection panel, we had a law professor, and in my particular case, it was Douglas Baer from the University of Chicago. I was scared to death when I went into the interview that he was just going to throw some substantive questions at me and not know what they were. You just never know. He did not, however. He did not. It was actually a very pleasant situation. In my year, there were 2 openings when I applied, and while I was in the application process, a 3rd opening opened up. As I understand it, there were something like 81 applications for the 3 spots. And then they only interviewed about 6 people. So they really do a lot of work before you hear a word. And we'll talk a little bit more about the FBI check, but then, that's the really interesting part of it. Mary Jo?
So I was just going to say that, based on my somewhat limited understanding, but I know that different circuits value different kinds of background, and we're going to talk about the importance, but I think it is important to know what your circuit is emphasizing, because for a long time, the Ninth Circuit really didn't value government service. And the first time I applied, I hadn't had any private practice experience. And so I think that was one of the factors that caused me not to get it the first time I applied. I know that in the Seventh Circuit, that's not true, right, Jan? That they...
The Seventh Circuit is a really weird circuit. And when I applied, I was either going to be in really great shape or really terrible shape. Up until myself and Tim Barnes and Don Castling all came out at the same time. Up until we applied, the Seventh Circuit had traditionally not valued bankruptcy experience. In fact, they didn't want bankruptcy experience. Carol Doyle was a litigator. Ben Golgar was a state court appellate practitioner. Gene Wiedoff was a litigator. By the way, he was a piano major in college. Pam Hollis was the only person on our bench at the time that we applied who had any bankruptcy experience. And the concern was they didn't want anybody applying who was too close to the bar, thinking that there could be some inappropriate things going on. I guess maybe 100 years ago, there might have been when they had bankruptcy referees and the like. But in any case, so when I applied, I had no idea. I know I had a very good resume from some very good law firms and the like. I had no government experience, although I had clerked for a bankruptcy judge, and I had no idea what was going to happen. Lo and behold, as it turned out, they were actually looking for people who had some bankruptcy experience. We had a very good track record of getting big cases. They thought perhaps if we put some people on the bench with bankruptcy experience, it might help get a little bit broader kind of caseload in Chicago. And so Tim Barnes and I both, with big firm bankruptcy experience, were appointed at about the same time. So yeah, you just never know. I do say that I'm actually the only one of us here who only applied once. This was the only time I applied, and lo and behold, and I truly had zero idea whether or not I had a chance in the world. So it's an interesting process, and I think your advice, Mary Jo, about try to get a sense of what your circuit is looking for is a good idea. Interestingly, somewhere in my process, I called the Seventh Circuit executive once I think I got the interview. And he told me a lot more than I expected he would. I thought I just want to call and say hi. So sometimes you can find information from interesting sources. With that, I'm going to change the subject just a little bit and change the subject to talk about advice. Advice that we can give the folks who are on the call today, who might be thinking about whether or not they want to be a bankruptcy judge, or thinking for that matter about whether they want to be a judge in general. And on this one, I'm going to start with Kim. And I note that Kim was a bankruptcy law clerk that I was. So I'll be curious to know whether that factors into your advice about what people should think about and do. And more than that, advice in terms of the best way to go about getting yourself prepared if you want to apply for this job. Kim?
Well, having been a law clerk certainly made me think about it. One of the things I loved about being a law clerk and then love about being a judge is that I can look at issues without worrying about I don't have a dog in the fight, so to speak. And so I can look at questions, just where does the law take me? Where do the facts take me? And that is enormously interesting work for me. The other thing that I love about it is that I can take an issue which may have a very small dollar value, but it's critical to the party. And in practice, I probably couldn't have done anything with it because of the cost to the client. So it either been compromised or would have we just wouldn't have been able to do anything with it. So I love being able to dig my teeth into those and figure out how that works. I think if you have any interest at all, I would urge you to really think hard about applying. I think the more we can add to a diverse bench, the better our system will be. In preparation, just as a practical matter, I would keep a file on things like the CLEs you attended or that you taught, any articles you've written, any board memberships. If you look at the application, they go back a lot of years. And I fortunately have paper calendars because I'm old fashioned that way. But have I not had paper calendars and having moved firms, I would have had no idea what courses I taught, what CLEs I'd attended and the like. So kind of get a hold of a copy of the application if you can. They don't change a lot, I think, over time. And then just have a file in your desk where you put, I worked on this CLE. Going back to the point that Mary Jo brought up is that each circuit, and in our circuit, each appointment, the circuit may focus on different things. And our example would be in Colorado, our bankruptcy bench has always had one non-bankruptcy practitioner. So we had a gentleman who had been with the IRS. And he was replaced by a gentleman who'd been a personal injury lawyer. Lots of trial experience, but and Judge Cordova used to joke that he didn't know how to spell bankruptcy. And so we've always had one judge that fit that bill. We've also had a couple of judges that had an incredibly diverse range of experience within the bankruptcy practice. And so you may be looking at, with each given appointment, that you're looking at, this is the appointment that's going to fill that particular slot that the circuit's looking for. There are some common themes though. And the first I would say is it doesn't hurt to have as diverse a practice as possible. And that means representing as many of the constituencies as possible, because you will have a more complete understanding of the code if you've addressed code sections from different perspectives. Another thing that our circuit focuses on is whether or not the applicant has given back. So for example, over the years, I participated in, I can't tell you how many CLE programs. I've served on the local rules committee. I was on the Legal Aid Foundation board, which raised money for Colorado Legal Services. And I think increasingly courts are going to be looking closely at your efforts to make courts more accessible and your efforts to improve the court system. So those are some of my thoughts.
Thank you. Greatly appreciated. Lisa, as a recent appointee, what's your perspective on key advice that people who are thinking about applying someday should keep in mind?
Well, I think all Kim's suggestions are excellent ones, but I would add just a couple of other things. I think one of the things that Kim noted was, that your activities as a lawyer are important, but also your activities not as a lawyer or in ways other than just being a bankruptcy lawyer are important, and what else you do in the community and what else you do in the legal community are all important. I think those things do matter. I'm always one of those people that, like many of us, who had always done a lot of other things in addition to just being a bankruptcy lawyer. And I was always involved in a lot of different organizations, and it was just because those are things that interested me. And I think that that helped me because I wasn't just a bankruptcy lawyer. I mean, I did, for example, a bunch of my pro bono work was involving Violence Against Women Act cases. Just something I took on because somebody asked me to supervise a team one time of summer associates and young lawyers, and I didn't have any experience, but I took the training, and after I did it, I was hooked because I had so many wonderful clients that I actually helped along the way, and that had nothing to do with my being a bankruptcy lawyer whatsoever. It was just a great experience. I also think just being involved in whatever interests you is a good thing. I mean, I obviously, like Kim, had done a lot of different things. I was co-chair of our business and reorganization group in UJ that raises a huge amount of money every year and I was on the executive committee before that. I'm involved in Ovarian Cancer Foundation, where I'm on the leadership council. I'm on my dean's advisory board for my law school. I was on the board of ABI. I just have done a lot of things over the course of my career, but I started when I was younger, just, getting involved with organizations, not necessarily in the leadership function, but just to get out there and meet people and have an opportunity. So I think that was good. You should figure out what you like and try it, so I think that just helps to get out there. So that would be another thing. And then I think Mary Jo's advice about understanding your circuit is also important. That might have been daunting for me in some ways, if I think if I thought about it that way entirely, but because our circuit is, like many people, you have diverse backgrounds. So we have some people whose backgrounds look just like me. Judge Chapman and Judge Drain's backgrounds before they went on the bench were exactly like my background, for example, pretty much. But then there are a lot of people who work for the government. We have people who were in the U.S. Attorney's Office, in different roles. We have commercial litigators. We had a family law judge on our court one time who became a bankruptcy judge. We have, Judge Morris, who was the clerk of our court. So we have a lot of diversity in terms of where people's backgrounds are. So it's not one or the other. And I guess the encouraging thing I will tell people is they definitely should consider applying, because my baby judge school class was 65% women, which is good. And the age range was broad. I might have been the oldest person in my baby judge school class who was a woman at 58, but close anyway if I wasn't. And the youngest person in my baby judge school class who was a woman was 34. So you can't think you need to wait always. I mean, the people who are in their 30s in my baby judge school class are amazing candidates and wonderful judges. And they didn't sit around having another 20 plus year career like I did, or 31 years as I had in practice. So I don't think you should be afraid to apply. That's the other thing too. And I know for me, the first time I did it, I was very surreptitious. Only Rob knew I was doing it, a handful of my friends, that's it. And then I didn't tell my partners until I got the interview, because I just didn't, think that. And even today, many people in the New York bankruptcy world think I was insane for doing this. You either end up with people who think what I did is great, and it's good for the bench, or you have people who think I'm nuts to give up a job like I had for a 93% pay cut. so, so you have to want to do it. And I guess the last thing I'd add is I was always a bankruptcy nerd, a person who just loved the bankruptcy code, loved learning about it, loved speaking, loved writing. That was always things I did just because I enjoyed them, not because my firm thought that was a good thing to do at all. Always, really almost because despite it that I like doing it. And this job has been wonderful for me because it gives me a chance to, as Kim was saying, enjoy looking at these issues and focusing on them and not having to worry that my rate is $1,575 an hour, which is what it was before I took the bench. And how can I spend any time on this? So that's a nice thing too.
Yeah, when I hear all the things that Lisa did before he got on the bench, I'm like, how did I ever get this job? It's like, yikes. I will say this, and I want to turn to Mary Jo. One of the things you don't have to have is you don't have to know bankruptcy, and you especially don't have to know consumer bankruptcy. I was scared to death. The very first call I ever had was a Chapter 13 call, and the very first time I ever looked at Chapter 13 was when I got the job. It's your judgment, it's your gut, it's your ability to digest information. I mean, there's so much more that goes into being a judge than just knowing the substance. One of the best judges we have on the bench in Chicago is LaShonda Hunt. LaShonda did criminal work. She worked for the Department of Probation. She worked for the U.S. Attorney's Office. I mean, it's the opposite of my background, and she is fantastic. And it's really cool when she gets people in her courtroom that are hard to deal with. You do not want to mess with LaShonda. She knows how to deal with them. With that, Mary Jo, any advice you'd like to impart to our audience today?
Sure. So I think in addition to the things that all three of you identified, I think, trial experience is extremely important. And if you're, it's harder and harder these days to get trial experience. So if practice doesn't give you the opportunity, go out and do a pro bono trial, even if it's not a bankruptcy trial, because particularly the circuit judges, I think from the questions that they asked, were very focused on, can you handle a courtroom? So if I think that's very important. Obviously, your reputation is extremely important, and in the heat of battle, sometimes you can get angry, and it can cost you on these application processes. You always want to be have the most stellar character and reputation that you can possibly have. In terms of practical advice, a couple of things. One of the best things that I did before getting the job, which was my third try, was doing a practice interview, and have your friends prepare you to answer the question that you least want to answer. I mean, I think we maybe all had some gaps in our background or something that we were uncomfortable with, and being able to handle that difficult question. For me, frankly, it was my age, which I didn't think I was too old, but I was 1 month short of 65 when I got the job. And I had lunch before the initial screening interview with the judge I clerked for, who was then about 97. I said, well, I'm feeling really good, but I'm a little worried that they're going to think I'm too old. I don't think I'm too old. He said, how old are you? And I told him, he said, you're screwed. This was right before the interview. So as it turned out, I wasn't, but I had done the practice interview, and the answer I gave to that, are you going to stay 14 years? Because that's the obvious question that's related to age. Was I recounted the conversation that my son and I had had. My son said, is this a job you keep till you retire? I said, well, it's a 14-year term, so I'll probably be ready to retire. He said, Mom, I'll retire before you do. So it was kind of deflecting that. And, it really helped, because one of the things that's so important is for you to be yourself in these interviews, because Chambers is a very close group of people. And one of the key things that people are looking for is, will they enjoy having you as their colleague? will you get along with people? Because if you don't, can be a very miserable experience.
Yeah, one of the things you may have gathered from what we've said here so far, or if you haven't, I'm going to say it outright because it may have been said once before, is this is the best job ever. I mean, this is the absolute best job ever. My children had somewhat the same reaction yours did, Mary Jo, which is, Mom, you're never going to retire. Who are you kidding? I mean, we love our job, and this is a great job. I, like Lisa, took a huge pay cut for the job. And for me, at my age, where my children were, they were both finishing college. It was actually, the timing worked out very well. You know, I'm not sure any of us really think too hard about that because it's just a great job and it's so much fun and we enjoy it so much. With that, I think it would be really fun if we sort of tell our audience what is a typical day in the life of a bankruptcy judge. Because it might not be quite exactly what anybody thinks. So Mary Jo, why don't you start us off? What's a typical day in the life of a bankruptcy judge? And I understand, and we'll have to put a big asterisk next to these answers because it's not been the typical life of a bankruptcy judge for the last 14 months.
Well, our caseload has been relatively low. So when I first got there, I kept looking for all the emails that I used to get in practice, and none of them were coming in. It sort of freaked me out, and it was sort of quiet. But you know, with that comes a lot of ability to both prepare for the cases that you do have, get yourself prepared for issues by keeping up on current cases and learning. I mean, I've been just blown away by the amount of information that we have access to on any topic, you know, not only substantively, but, you know, I can pick up the phone and call any of the people on this panel or most anybody on the bankruptcy bench and bounce things off of them. And so, you know, a lot of times, for example, my background was commercial bankruptcy, and my colleague in Tacoma, it was a Chapter 13 trustee. So we spend a lot of times on each other's cases, bouncing ideas off of each other to help each other, you know, analyze and reach a decision and understand issues that we might not otherwise understand. So, you know, sometimes it's preparing for the calendars that we have on a regular basis. Sometimes it's preparing for trials. Sometimes it's writing decisions. I have had a fair amount of time to do what I used to call non-billable work, in the sense of, you know, doing a lot of public service, continuing the things that I think all of us did as practitioners, in terms of, I'm working with the Veterans Committee of the ABI to develop financial literacy program. We also have had a very active extern program. So I regularly have externs, so helping them learn about bankruptcy. So hopefully they will become future bankruptcy judges. You know, writing. You know, I can't do anything about the caseload. You know, we no longer market on that front, but I never have a time when I'm bored or don't have something to do that's related to the law somehow.
Kim, what's the typical day in Colorado?
Pretty similar to Mary Jo's description. If it's a day that I don't have any hearings, I'll work on draft opinions. We have an enormous number of resources available to keep up to speed with the law, so I enjoy doing that. I often look ahead to my dockets that are coming up and figuring out what I've got, what's going to go forward, what isn't. We have a system in place where things percolate up from the case administrators up through my courtroom deputy and my law clerks to me. So there are some things that the courtroom deputies will handle, like motions for extension of time, or at least the first or second ones. By contrast, a motion for 2004 will percolate to me and I'll look at that. But I found one of the biggest differences is that when I was in practice, I had a secretary and a paralegal who worked for other people. And now I am swimming in highly competent people who, frankly, I think sometimes know more than I do. And they really make this job amazing, because I have all these folks with decades of experience in the court. If I have a non-evidentiary hearing, that we're now doing those all by telephone. Again, I'll review the cases, I'll review the pleadings, and prepare for the docket, reviewing any case notes. And then if there's an evidentiary hearing like I had today, you prepare for trial, you figure out what, where you think the case is going, what you think the issues are, and then you find out from the attorneys what the issues really are. But I do have time to do those things that I enjoy. So like Mary Jo, I've been doing a lot of work with the CARE program that we're developing, the credit abuse resistance education program that we're developing in Colorado and Wyoming. I've done, I've spoken at different CLEs, very similar to what I did in practice, but people I think listen more now for whatever reason. But it's, it's a different pace because, like Mary Jo said, you've done the phone does for me. And that took a little getting used to. But when I call somebody, they call me back more quickly than they used to. So it's, like everybody said, it's the best job ever.
I was at a conference one day when somebody was talking about the great thing about being bankruptcy judges. They said, well, two things. Number one, you walk in the room and everybody stands up. And the other thing is you tell a joke and everybody thinks it's funny. What's not to like? And with that, Lisa, you have been on the bench for 3 months, all virtual. You went from a huge firm practice to a virtual bankruptcy judgeship. I can imagine your typical day is quite different these days.
Well, maybe not than it was the last year because everything was virtual then. It's just the other side of hearings.
Yeah.
So, I wasn't in the last year before I went on the bench, was all virtual. I was working out of my living room. So now I have my living room, chambers, but it's how it is. And we've started actually, my law clerks and I, to go in 1 day a week now that the three of us are fully vaccinated, to our chambers. Just, so we get to work together in person, which, I just felt was better for mentoring. It was their suggestion too. So it was definitely a good idea. And I think it's just the opposite side of telephonic and Zoom hearings that I had in practice, a little bit of that. My caseload, that's been, I guess my typical day is, I have hearings on most Tuesdays, Wednesdays, Thursdays, not always, depends on the calendar, but that's generally it. I try not to have my hearings Monday and Friday. That's sort of a Southern District thing, I think, by and large here. So I've just followed that. I would say everybody in my chambers, the only person who really knows what they're doing is my courtroom deputy, who's been doing this for years and was Judge Bernstein's courtroom deputy before. So the rest of us, it's the Wild West. You have 2 law clerks and a judge, none of whom ever did this before. So that's also kind of interesting. Obviously, there's a lot of things that are new for me. Maybe not new in the sense that I've seen them in practice, but new from the sense of being on the other side of it. So that's been fun. Last week, I had to decide what I was doing about someone who decided to take money out of an escrow account and put it in a DIP account without getting a court order. And the order basically was clear that it had to stay in the escrow account. So that was bad. And then I also had a state court judge, after somebody filed an intervention for a state court action, who decided not to pay attention and doesn't think intervention means anything. And that he still had jurisdiction. So I had to call him. So that was, I have every week, it's something different. I don't know what it'll be like to have hearings in my courtroom because that I haven't seen. So that will be new for me. I'm looking forward to it when it happens.
For sure. Yeah. And what's interesting in what you're hearing is we do a lot of different things. I mean, we don't, if we're in a big case and a big trial, we might be in court a lot, but we do so many different things outside of actually being in court. I happen to have a very large and busy calendar right now. I inherited a couple of cases, one of which has more motions to dismiss than you can possibly imagine. And it seems the minute I finish one, I have to start the next one. So I'm doing a lot of reading and writing in my chambers when I'm not in court. But I'll say that like the others, I'm very involved in care at both the national level and the local level. I'm involved in ABI. I'm involved in the NCBJ, the education committee there, as is Lisa. I'm involved in IWIRC here, you know, on the board in Chicago. We really are encouraged to and have the opportunity to get out in the community and teach and learn and communicate. I mean, one of the goals of the NCBJ is to have a forum where lawyers and judges can talk with each other, work together, collaborate with each other. And you know, that this job gives us the opportunity to do that in a really nice way. We have about 10 minutes left in this program. We are fielding questions. If anybody wants to put anything in the chat, it will be sent in to us. In the meantime, I'm going to turn to what I think will be our last topic of the evening, which is what's the most surprising thing about this job? And I'm going to start off by telling you the most surprising thing about this job hit me my first day on the bench because it was a Chapter 13 call. And that was 2012, when my Chapter 13 calls would be about 500 matters at a time. They're a little less than that now, but not necessarily less challenging sometimes. But what was most surprising to me is the tremendous amount of discretion we have, even especially, I think, in a consumer case. You know, this is a code-based law, right? You'd think we have rules and regulations and procedures, not so much. You know, I find myself on a daily basis trying to decide what's the right thing to do. Does this person need another chance? Is this person telling me the truth? Is this person going to do what they can do? Do their finances suggest there's any possible way they can? And it scared the heck out of me at first, the amount of discretion I had. And I had to kind of say to myself, well, the Seventh Circuit selected me because they trust my judgment, they trust my gut. And you know what? You trust your judgment, you trust your gut, and it works. With that, Mary Jo, what's probably the most surprising thing about this job to you?
Well, I don't know whether it's surprising as much as it is something that I think I'll struggle with. Oh, it's on. You can't hear me?
Yeah, we can hear you.
Oh. As it is something that I think I'll struggle with till the day I leave, which is, you know, the word judicious and when to insert yourself as a judge and when not to. And, you know, I really hadn't realized how impactful just the slightest thing that you say, you know, can sometimes be, or, you know, and how it can sometimes turn a case in a direction that maybe you didn't want it to go. You know, you have to keep a poker face the whole time, which after having phone hearings, I'm going to tell you, it's going to be really hard to go back to live hearings and keep a poker face. But you know, I struggle with it and I think about it a lot. And, you know, it probably varies somewhat for me between consumer cases where I might be a little more what I'd call activist, particularly if I see a lawyer not doing their job and a client being hurt. But in commercial cases, I'm very, very careful about not inserting myself, because one thing you learn, and this was surprising to me, I used to think, why isn't the judge understanding this? Well, the only way the judge understands what's going on in a Chapter 11 is if you tell them what's going on in a Chapter 11. And if you were a Chapter 11 practitioner, you know, you have some sense of what's going on, but, you know, 9 times out of 10, you don't know until they appear in hearing and tell you, you know, they settled or they didn't settle. And so not having that, you know, kind of information all the time, you know, is something that you have to sort of work your way through. And I really hadn't appreciated that as much sitting on the other side of the bench.
Great, great. Kim, what about you? What's maybe the most surprising thing that you've discovered about being a judge?
I would kind of go off what Mary Jo said. I can remember sitting in court and thinking, does the judge just not get it? when the other side was misbehaving. And the reality is we do get it. We know what's going on, at least at some level, because we've been there, we've been in the trenches, but we just don't say anything. And you do have to keep that poker face. You do have to, you have to be careful with your words. And I'm very careful with my words. There are times though that I have found, and it's the hard part about weighing when you let the parties play things out, and when the parties really need you to get in there and say, all right, this is what we're going to do. And sometimes, I'll give you an example. I recently had a hearing with an attorney whose client was the lender on property, and the debtor wanted to pay real estate taxes and HOA dues. And the attorney, you could hear him kind of going, okay, Your Honor, I'm objecting to this. And I finally said, isn't this priming your client? Isn't this priming? And yes, and like, well, why do we not have an agreement here? And it was sort of the thing he needed to go back to his client with and say, the judge is looking at you as though you're insane. And so it's finding that time when you have to kind of give the lawyer what they need to have some help to address something with a client, and just that weighing that goes on, and trying to figure out where you step in and I want to step in and help and not meddle. So I think that to me has been one of the biggest surprises and challenges.
It's interesting you say you want to step in and help, but not meddle. We have to be very careful who we help. And the fact is, we can't help either side. So it puts us in a very, very difficult position. Lisa, we've got about 3 minutes left, and you've been on the bench for 3 months. So I would imagine you'd have some pretty big surprises in the first 3 months of your term here.
Okay, sorry, I think I was on mute there for a second. So I think for me, I am definitely a Budinsky, so that is the hardest thing for me to struggle with. So I totally understand what the other judges are saying. I'll just say that, and I don't think I'm very good with controlling myself sometimes now, but I try. I think the diversity of everything that we deal with has just been amazing to me. I mean, I think I expected it, but I think just seeing it, I've had to learn so much about everything from New York rent stabilization law to, issues about, how different, areas of practice all, works, and issues that come up for individuals that I haven't seen, and just everything is different. So I think I've found that to be fascinating for me, even though I expected it to be diverse. I think it has. And the other thing I think that has surprised me in a good way, and I think Kim noted this too, is how responsive people have been in the government. I was sort of expecting working for the government to be awful in some ways. And I will just say that hasn't been my experience at all. It's been great. I've gotten all the help I needed and more. And there's all these resources for us. And anytime I have a problem, people are there. And I think that's been, great. And I think I had my perspective after being in a large firm was expecting it to be not good. And it's been great.
Yeah, and with that, I think we need to wrap up, but I'll say that the other thing that's part of that is our colleagues are so amazing. If any of us have a question and we can't figure it out, all we have to do is send an email to any other bankruptcy judge in the country, and we'll have an answer or dozens of answers right away. We are the most collegial group of 320 or so people you can possibly imagine, and we talk to each other and we help each other, and it really, I think, makes for a much better bench. And with that, I am going to have to conclude and thank our fellow panelists, Lisa Beckerman, Mary Jo Heston, Kim Tyson. It has been so much fun. We hope that we have imparted some help and wisdom to all of you. We very much encourage everybody, if you're thinking about this, apply. We really, really would like to see the most diverse, most interesting, most congenial bench possible. And that means everybody from all walks of life should really consider looking at this as a career path for them. And with that, I think that concludes the session for the day. And I'll just say it's been a lot of fun. Thank you, everybody.
Thank you.
Thank
Thank
you.